So friends, today since we are a mixed group of people, we have some lawyers, we have some law students. I can see some social workers here as well. So since we are a mixed group of people, we will have a more socio-legal understanding of the Domestic Violence Act. I will highlight basic sections of law that are relevant and important in understanding the law, more or less based on experience on what kind of orders can be got or what is the procedure are some aspects that I will try and talk about as a part of my session. So as we all are aware, the Domestic Violence Act is actually a law that talks about protecting women from the domestic violence that is happening in the families, and this is the law that came in the year 2005. This law is civil in nature. It is a law that provides women the needs that they have. So this law is civil in nature, and there is only one section, section 25 of the law, section 31 of the law, which is criminal in nature. So as we see, this law is trying to address the gender inequality that is there in society. And we know that domestic violence is a public health issue. And keeping these aspects in mind and considering the rising cases of domestic violence that were reported before COVID, during COVID, and even now after COVID, we see that the government was required to take an initiative to talk about and bring about a law. So a lot of effort has gone in from many feminist groups, a lot of organizations, to bring this law to protect women from the violence within their family. Now, this law has come in the year 2005. It is first of its kind, which addresses all kinds of domestic violence. Now, in a family, you have a wife, a mother, a sister. You have women who are in various relationships. You have women who are daughters. You have women, who are part of the joint family system. There was no law to protect such women from the domestic violence that was happening in the family. So earlier we had Section 498A, which was used to protect women, or to punish the respondent, the accused, who committed cruelty on the woman who was his wife, and the husband and his relatives were then charged under Section 498A. Another section that we had, Section 304B, that is the dowry death. So, if a woman within 7 years of her marriage has faced harassment for the demand of dowry, and the demand of dowry is seen, visible, recorded, then in such cases, if the woman has died within 7 years of marriage, we see that Section 304B was attracted. Now, at that point in time, if women wanted to claim maintenance, they wanted money for their day to day expenses, they needed money to look after themselves, their children. They had Section 125 CRPC and various other personal laws that spoke about maintenance. But when it came to a sister, when it came to a daughter in law, when it came to other women in the family, when it came to a mother, there were limited laws that provided reliefs to them in terms of protecting them from domestic violence and providing for other basic needs like shelter. Then we talk about maintenance, then we talk about compensation. And so this is first of its kind, a law that is civil in nature, that is addressing all domestic relationships, and it is talking about protecting women from domestic violence. This law is civil in nature, although the law functions in a criminal court, in the court of a metropolitan magistrate. We have a civil procedure code, we have criminal procedure code. In the same way, we have courts that deal with civil law, courts that deal with criminal cases. Now, the Domestic Violence Act in Mumbai functions, or the cases are filed in the court of the metropolitan magistrate. When we go to places like Thane, you will have it filed in the JMFC court. So, a law that provides for the needs that women are looking at, and that is why the reliefs in this law are civil in nature. One important aspect that I have come across while dealing with cases of domestic violence are, very often women come and say, I want a divorce. I don't want to stay in this marriage. I want a divorce. So it is very important for us as lawyers and law students to note that divorce is not a relief under the Domestic Violence Act. The purpose of this law is to give effective protection to women based on the constitutional rights that are protected and provided for them. Now, when we talk about constitutional rights, we are all aware that we have a right to equality, we have a right to protection from any sort of violence, which is embodied in our right to life. Then we have a right to freedom of speech and expression. We have right against discrimination. So there are these basic rights that are provided, fundamental rights that are provided to citizens, to women who are in the country. And when women have faced violence, based on the fundamental rights, the laws have been enacted. We have the Article 15.3, 15.4 of the Constitution, which talks about positive discrimination in favor of women. And that is why we see we have laws that are enacted for women. And Domestic Violence Act is one such law that has been enacted to enable women to enjoy their right to life and to be treated equal and to be protected from any form of discrimination. As I said, this is one law which is different. It also protects women who are in a relationship in the nature of marriage. There are several judgments of the Honorable Supreme Court and as well as judgments of the High Court which talk about live-in relationship. Now, whenever I conduct trainings, I normally ask people, since when do we talk about live-in relationship? So basically, from the year 2005, this word live-in has been hitting our ears quite often. Now, what is a live-in relationship has been defined by the honorable courts. However, the intention of this act is to protect women who are in a relationship in the nature of marriage. Now, what do you mean by relationship in the nature of marriage? Many of you are aware when you talk about court marriage, people say, where do you get married in court or court marriage kahan hoga? They'll say it is Bandra court. And we all know that there is no court marriage happening in Bandra court. However, there are people who form or perform such marriages, form such groups and arrange for such marriages, which may not be recognized by law. There may be a marriage where either of the party had a spouse living. So I had a case where a man had 3 wives. Now, the first marriage would be a marriage recognized by law. But the second marriage and the third marriage, without the divorce taking place in either of the marriages, would be relationship in the nature of marriage. So very often, people are not aware of the marital status of their partner. And after they are married, they get to know, oh, my partner had a living spouse. And without a divorce from that spouse, the partner has married me. In the city of Mumbai, we face a problem where many persons have their spouse in their villages and they have left the spouse there and come to the city for their professional commitments to look for job. And here they start living with a woman and they start a family with the person and they perform a ceremony within the closed doors with a few friends that is convenient for them, not to inform the society that they are married. Now, in such cases, when such marriages or such relationships take place, we see that women are protected in the form of relationship in the nature of marriage. And this, according to me, is a very important highlight of this law. We also have the registration of marriages that are not done very frequently. And very often, women do not have any proof of their marriage or they cannot establish that they are married. So, very often, when a case is filed in court where a man has a spouse who is alive in the village, the normal defense that he comes with is, see, I am already married, I have children in the village, I have a family established in the village, and this lady is not my wife. We just live together. And because she's not my wife, she does not have a right to maintenance. Now, the personal laws, like the law that talks about maintenance with regard to Hindus, Muslims, Christians, these laws talk about maintenance to a wife. But the Domestic Violence Act talks about maintenance to any person where you have been in a relationship in the nature of marriage as well. Then it talks about a non-matrimonial relationship. So 498A section talks about cruelty on a woman by her husband or relatives of the husband. Here we are talking about domestic violence which is caused in non-matrimonial relationship. So any woman who has been in a relationship either as a mother, sister, wife, or a part of the joint family can also get benefits under the Domestic Violence Act. What is domestic violence? The law defines domestic violence as any form of abuse caused or any form of harm or injury which is physical or mental in nature, and it might affect the life and the safety of the woman. The definition also embodies any harassment for dowry or to meet any other unlawful demand. If there is a threat to cause injury or harm, that again is a part of the domestic violence definition. And it talks about overall facts and circumstances of the case. Now, this is a very broad definition that the law has provided us, and it goes on to then categorize domestic violence to be physical, mental, emotional, economic, verbal, and sexual. Now, the law defines these five kinds of violence to be a part of domestic violence. Now, what is physical abuse? Physical abuse is visible. We see it. Emotional abuse is the taunts. Economic abuse is when a woman is deprived money. When generally there are cases where mothers who are working are denied salary by their own children. Verbal abuse is the normal gali galoj, giving bad words. Sexual abuse, so when we talk about sexual abuse under the Domestic Violence Act, we are all in the process of discussing aspects of law that do not come within the ambit of the Indian Penal Code. So marital rape, something that does not fall within the ambit of the Indian Penal Code. However, if a couple is living separate and then there is a forceful sexual assault by the husband on the wife, that would amount to rape. However, under the Domestic Violence Act, if there is sexual violence, if there is the husband has forced his wife without her consent and performed a sexual act, or deprived her of sex, or showed her pornography, all of that would amount to sexual violence. Now, when we talk about domestic violence, commission of the act and omission of the act both would amount to domestic violence. So if you are responsible for maintaining this particular woman and you did not maintain her, you did not provide for her needs, you have omitted your duties, and that would amount to domestic violence. There is a case where a lady lived with her husband in a house, and there was no communication between the husband and wife. The husband refused to talk to his wife because the dowry given at the time of marriage, according to him, was not sufficient. Now, this act wherein the husband refused to talk to the wife or communicate with the wife in any form would also fall within the ambit of the Domestic Violence Act. So, the law talks about commission and omission. What are the reliefs? The reliefs are civil in nature. One is protection order, section 18. It talks about protecting the woman who's a complainant or the aggrieved person from any sort of physical, mental, emotional, sexual, or economic abuse. So the law is a law that is talking about protecting women from domestic violence. And that is why the first order that we have to pray for or ask under the Domestic Violence Act is a protection order. The law is to protect women. Very often, I have seen in cases that are filed in court through lawyers, they do not ask for protection orders. They ask for maintenance orders, they ask for custody orders, they ask for residence orders. But they say, nahi, once the case is filed in court, we will not need protection. And so they do not ask for protection orders. But the law itself talks about protection. So protection has to be an important element of the prayers that we are asking for on behalf of our litigant. Now, when we talk about protection orders, it is very important for us to understand that the law, the book that we have, the Bare Act that we have, also has formats with regard to what is a Form 1, Form 2, Form 3. And if you have the Bare Act, you will see that Form 1 is a domestic incident report. And there, the nature of the orders that can be sought are mentioned. In the same way, Section 18 of the Act provides for orders that can be sought. Now, in these orders, one advantage that all of us have is, depending on the nature and circumstances of your case, you can ask for specific orders in terms of protection. Like in one case that I had, it was a lady who was married to a man who did not consume root vegetables. Now, in that case, root vegetables were not allowed to be cooked in their house. And whenever food was cooked, the husband would just throw it out. Now, in such a case, when you're asking for protection orders, you are asking specifically for a direction to the respondent not to interfere with the food that is cooked in the house, and to allow the applicant to cook food that has root vegetables in it. Now, this is the specific provision that the law has for us, wherein we can ask for specific protection orders. There was another case where a husband hired the driver to commit violence upon the wife. So, whenever the wife was at home, the driver would commit violence upon her in different forms. And so a specific protection order was direct the respondent not to abet violence through the driver. So these are specific orders that we can ask for. Second is residence orders. Now, when we talk about residence orders, we are talking about a woman's right to reside in that house. And residence orders would mean, one, that her Stridhan should be returned to her, which is a part of Section 19 of the Act. Second, to provide rent for a house that she is residing in, if it is on rental basis, or to allow her to reside in her own house peacefully. And Section 19 of the law also has a special provision where, if it is found that the respondent, male respondent, has been committing violence and it is important to tell him to leave the house, then a special provision under the law allows us to get a direction wherein the male respondent can be told to leave the house as well. Monetary relief. One important aspect with residence orders is it only talks about the right to reside in the shared household. It does not talk about ownership rights with regard to that particular household. And this is one area which is still gray, because when we talk about the Senior Citizens Act, the Maintenance and Welfare of Parents and Senior Citizens Act, we see that there is a provision for eviction. And here the Domestic Violence Act says that no woman can be told to leave her house. So these are some areas that need a little more deliberation, and maybe based on the facts and circumstances of each case, the orders can be prayed for accordingly. Monetary relief. Monetary relief is one aspect of law wherein we hear the word maintenance, which is used everywhere. Okay, maintenance is defined as basic right to food, shelter, clothing, education, medicine, etc. But when we talk about monetary relief, your monetary relief talks about the money that the person, you're specifically a woman, would need for her own survival, the money that she has lost when she has faced a loss in her job. Then we talk about compensation to her because of some physical injury that has been done to her, or if she has had to have some medical examination, medical expenses, then that is also given to her as a part of monetary relief. The ambit of Section 20 is quite wide. Now, Section 20 also talks about how do you get or execute an order when an order of maintenance has been given or provided. Okay, so it has a provision of Section 20, subsection 6, which says that a notice can be sent, or the court can direct the employer of the respondent to debit that amount of maintenance that has been ordered and directly pay the maintenance to the applicant. Custody order, Section 21. The custody order under the Domestic Violence Act is interim custody order. So the Guardianship and Wards Act, the Hindu Adoption Act, the guardian, the other laws that talk about a male or a father being the guardian of the child, the Special Marriage Act, all of this are supreme in terms of custody orders. The custody in the Domestic Violence Act is only interim in nature. It is only for the time being. And if there is any other order from any other law, then the applicant and the respondent have to abide by that order. Compensation order, we are talking about compensation for domestic violence that is caused. And one of the very important defenses that can be taken in a domestic violence case when you are for the respondent is whether domestic violence is caused. And if domestic violence is not proved prima facie based on the facts and circumstances of the case, then none of these orders can be given to the applicant. And in a similar fashion, a lot of courts have held that compensation amounts, that are claimed are not justified by the impact of the violence that has been put out in the pleadings. And that is why in very few cases, compensation orders have been given. Interim ex parte orders, I think this is one of the highlights of the law. The law talks about ad interim orders. Now, the law provides that within 3 days of filing of a domestic violence complaint or application in court, the respondent is required to be present. And within 60 days, the case has to be decided. However, considering the load of cases and the nature of the proceedings in court, we are aware that it is not possible, or it is rather difficult to have the case conclude in 60 days. And in such cases, the ad interim orders that are passed under the Domestic Violence Act benefit the parties to the case. Now, the BEAR Act has a sample of Form 1, that is the Domestic Incident Report. So, like in criminal law, we have a FIR. Here we have a Domestic Incident Report that is called a DIR. The protection officer, who is a very important stakeholder under this law, has the authority to file a domestic incident report. Other than that, a medical officer has the authority to fill a domestic incident report, and a service provider, that is an NGO registered under the law, has the authority to file a domestic incident report. A domestic incident report can be submitted in court only by these three stakeholders. A lawyer or a police cannot file the domestic incident report. The next is application to the magistrate. So the Domestic Violence Act is a very victim-friendly law. If the woman is qualified, she can herself present her case in court, and that is why Form 2 is the application that is presented to the magistrate. So we have Section 12 of the law that talks about how to approach the court with your application for reliefs under the Domestic Violence Act. So that format is already provided. Now, Form 3 is affidavit in support of interim reliefs. If we see Section 23 of the law, Section 23, subsection 1, subsection 2, they provide for interim reliefs. Now, if the magistrate is of the view that prima facie domestic violence is seen and the woman needs to be protected or given immediate reliefs, then based on this affidavit, ex parte ad interim orders can be given in a particular case based on the facts and circumstances of the case. And then we have Form 5, which is a safety plan. Now, when a protection officer files a case in court, on that basis, these are all forms that become a part of that whole bundle that is given. So, as a lawyer, if you represent the respondent and a case of domestic violence is filed by the protection officer, you will have these forms that become a part of the pleadings that are there, which are more or less in Marathi for Mumbai and Maharashtra. But these forms, each of these have to be responded to as a part of your pleadings for the respondent or the opponent. Now, one important feature of this act is the right to reside, Section 17. In cases of domestic violence, based on surveys and data that is collected, it is seen that very often women are thrown out of their house, or they're threatened to be thrown out of their house. And so this is a law that talks about the right to reside. So every woman in a domestic relationship has a right to reside in the shared household, whether or not she has a right, title, or beneficial interest in the same. So if a couple, okay, is staying in a company quarters and it is given to the husband as a part of his employment, then the wife has a right to reside in that house. If a son is employed somewhere and he gets a company quarters and his mother resides with him, the mother has a right to reside in that house. And under section 19 of the law, she can get an order that she should continue staying in that house. Now, if a woman has to be evicted from the house, we have to follow the civil procedure for eviction. So, no woman can be thrown out of the house without any procedure of law. And this is very important for us to understand because we read section 17 along with section 19. And this is the conflict that we see with the Senior Citizens Act that is there, because there is a provision for eviction, and here we say that without procedure of law, women cannot be evicted. And section 19 says that no woman can be evicted from the house. Only a man can, by and large, be evicted. So these are some challenges that the law poses before us. Right to reside has a lot of judgments. However, one judgment that I thought was relevant for us is the Roma Rajesh Tiwari judgment, wherein it talks about securing the right of a woman to reside in the matrimonial house, whether or not she has a right title of interest. So there have been judgments, of the Honorable Apex Court, which were not in line with this judgment. However, we see later on that the judgment, in keeping with the intention of the law, has become the norm now. And there are quite a few judgments which uphold the right of a woman to reside in the matrimonial house, whether or not she has the right title or interest. Now, when can a woman seek help? As a lawyer, the person can come to you before the case is filed, during the case proceedings in court, or even after the case has been filed, decided, and there is a judgment. Now, in such cases, we need to become aware of how we can provide her with assistance. One, at a pre-litigation stage, as a lawyer, we would generally file a complaint in court. So as a lawyer, yes, under section 12 of the act, we can also file a complaint or an application under the Protection of Women from Domestic Violence Act. In addition to that, since it is a matrimonial dispute by and large, or it is a dispute between a mother and a child, okay, so it is family dispute. Very often we see whenever a family dispute is involved, people use ways and means to try to settle or resolve the matter before it goes to court. So under the Domestic Violence Act, the matter can be referred to the protection officer, who is a government appointed officer, who is the bridge between the aggrieved person and the court, and all the major filings are done through the protection officer. Then you have service providers who have counseling facilities with them. So you can also send the person to the service provider if they need help. There are shelter homes that are provided by service providers, medical services. Then you have the police, and we also have the District Legal Services Authority that has a lot of services that victims of domestic violence can avail. And now we have something called as a one-stop center. So a lot of women who approach the District Legal Services Authority or who approach the protection officer for protection from domestic violence are referred to a one-stop center. Now, what is a one-stop center? It is an initiative of the government where at one center, a protection officer is available, a doctor, a lawyer, and services of the police are provided. So it is a one-stop center where a woman can get shelter, she can get legal help, and she can get medical help as well. Now, these one-stop centers are an initiative of the government across the country. And so women who are victims of violence can benefit from the scheme of the one-stop center. In some places, they are also called as Sakhi centers. Now, can the police file a FIR or a NC under the Domestic Violence Act? So very often when I get clients who call and say, Madam, I had gone to the police, but they refused to file a FIR under the Domestic Violence Act, or they refused to file a NC under the Domestic Violence Act. So friends, under the Domestic Violence Act, at the pre-litigation stage, the police cannot file a NC or a FIR. However, they can report domestic violence under provisions of the Indian Penal Code. So 323, 324, depending on the nature of the violence that has come before them. And very often in cases of domestic violence, physical violence gets reported. Emotional violence is reported in the form of a NC, wherein threats are recorded, or assault by hand or assault is recorded. Okay. So these are ways in which domestic violence cases are reported at the police at a pre-litigation stage. For us to understand basic concepts in the Domestic Violence Act, one is aggrieved person. So, who is an aggrieved person? Any woman who is or has been in a domestic relationship with the respondent is considered to be an aggrieved person. Even a child, be it a boy or a girl below the age of 18, is defined as an aggrieved person under the law. Who is the respondent? Respondent is any person who is in a domestic relationship with the aggrieved person, and this person has committed violence upon the aggrieved person. So these are some aspects that are important for us to understand. Now, when we talk about an aggrieved person, it is any woman she's presently in a relationship, or she was or has been in a relationship with the respondent, and the respondent has committed domestic violence upon her. Now, when we talk about is, the relationship continues, or even earlier she was and the violence continues, then we have the provision of law. And any child can file a case of domestic violence, and this child would also fall within the ambit of aggrieved person. Now, who is the respondent? Any person who is or has been in a domestic relationship with the aggrieved person, and against whom the aggrieved person has sought any relief under the Act. Now, we see in the judgment of Hiril Harsora, wherein adult male was removed, okay, or is not a part of the definition of respondent. So earlier we had adult male, now adult male is removed. So now even a woman can be made a respondent under the Domestic Violence Act. Domestic relationship, two people have lived together because either they are married or part of the joint family, or because of adoption, or because they are part of they're related to each other by blood. So all of these relationships are covered under domestic relationship, and even relationship in the nature of marriage forms an important aspect of domestic relationship. For domestic relationship, again, we have judgments which talk about what are important elements to be decided for relationship in the nature of marriage. So, in this particular judgment, the Honorable Supreme Court has laid down guidelines, duration of relationship, whether they lived in the shared household, whether they were looked as husband and wife in the society, whether they have children in that from that relationship, and how did they live together as a family. So these are some aspects which have been defined by law, and they have been put into perspective by this judgment of the Honorable Supreme Court. Now we have another judgment of the Bombay High Court. Now this judgment talks about relationship where they have been living together. Okay, so at any point they lived together. So even if they do not live now, but they lived in the past, even that would fall within the ambit of the domestic violence case. Shared household, any household where the aggrieved person and the respondent lives. Now, very often in cases of domestic violence, when the aggrieved woman approaches the protection officer, goes to the protection officer to file a complaint, or comes to a lawyer to file a complaint, they provide a list of people against whom they want to have their offense or the complaint registered. Now, very often it is important for us to understand that under the Domestic Violence Act, any person cannot be made a respondent if the person has only inflicted domestic violence. Okay. So if someone over the phone has been abusive, taunted, that person cannot be made a respondent. It is important for you to mention in your complaint that you have lived together with that person at some point in time in a shared household. So for every person that you want to implead as a respondent, it is very important for you to mention in your pleadings that yes, you have lived in the shared household with this particular person. Very often, magistrates do not issue notice to respondents where no case is made out that they have lived together. So this is one important aspect for us to understand. Jurisdiction, judicial magistrate first class, whether aggrieved woman lives presently or she lives permanently, or even a place where she's employed, a case can be filed under the Domestic Violence Act. And then we have cause of action has arisen. So if there was violence, there was fight, there was assault, then taking the jurisdiction of that place as well, the case can be filed. Ex parte orders. So section 23(2), like I said, if the magistrate is convinced that prima facie there is violence, then the magistrate may proceed to pass an ex parte protection order, thereby prohibiting the respondent from committing any further acts of violence. Nature of orders, ad interim ex parte. Then you have ad interim orders ex parte. If the other side does not come to court, does not mark his presence in court, then we can have ex parte orders as well under the law. Now, section 31 is the only section under law which is criminal in nature. So we have section 31 and section 32 that talk about a criminal offense. So if there is a protection order that has been passed, whether it is ex parte, interim, ad interim, and this protection order has been breached, has the respondent has gone against that order and committed acts of domestic violence, then it would amount to breach of protection orders, and the police can register a FIR under section 31 of the Domestic Violence Act, read with rule 15 of the domestic violence rules. Now, it is very important to understand that the police can file a FIR only after a protection order has been passed. Now, any breach of protection orders is a offense under the law, and the punishment would be 1 year. It may also include a fine. When we talk about breach of protection orders, there has to be a protection order, there has to be a breach, and this breach has to be reported. And the law also talks about bail conditions which are mentioned if there is a breach and if there is a subsequent FIR. So police can register a FIR under section 31 of the Domestic Violence Act in case of breach of protection orders. Another important aspect is section 14, which talks about counseling. So in normal litigation, we talk about mediation. We talk about alternate dispute resolution. So mediation and counseling are two different aspects. And Domestic Violence Act talks about counseling, and counseling is aimed to stop violence. NGOs can assist the aggrieved woman as service providers, and then we also can avail services of a welfare expert. These are the important stakeholders under the law. So protection officers, we have protection officers based on the police station jurisdiction. So every police station has one protection officer who has been allotted for that particular jurisdiction. A protection officer can be contacted in case of any emergency of domestic violence, and the aggrieved person can directly contact the protection officer. Then you have service providers. So NGOs who are registered under the Domestic Violence Act to provide services. We have counselors who conduct counseling on the directions of the court. So it is a court-directed counseling. And then we have the police, legal services authority, and shelter home facility. Now, legal service authorities provide legal aid. So if a matter is filed through the protection officer will then refer the matter to the legal services authority, and a legal aid lawyer will come to be appointed for the victim or the aggrieved woman who has filed a complaint of domestic violence. Important aspects of law, like I said, counseling is a very important aspect of the law, and it is one law that talks about counseling of both the parties, either singly or jointly, to stop domestic violence. Then we have alteration of the order. So if there is an ex parte protection order that has been granted, And subsequently, if the relationship between the aggrieved person and the respondent has improved and they feel that they do not need this particular order, they can request for alteration of the order. So the alteration of the order is another important aspect that can be availed. Very often, we see in cases of matrimonial dispute or family dispute, later on, after they undergo counseling or after some time has passed in the case, they want to reconcile. So, in such cases, alteration of order would be an important aspect. And Section 28 of the law, it is a good feature of the law which talks about power of the court to formulate its own procedure. But as a lawyer, you will have certain challenges because every court and every magistrate would want to adopt a different procedure because that is the power given to them under Section 28 of the Act. In addition to existing laws, so one aspect of the Domestic Violence Act is if there is a divorce proceeding pending, you do not have to file a separate case of domestic violence. In the same pending case, you can make an application under Section 26 and Section 36 for reliefs under the Domestic Violence Act. And this law tries to discourage multiple litigation. So wherever a case is pending between the aggrieved person and the respondent, that particular jurisdiction can be taken. And in the same pending case, an application under Section 26 and 36 of the Domestic Violence Act can be filed for reliefs that are protection orders, residence orders, maintenance, custody, or compensation.
So there are so many women who are misusing these laws, women domestic protection laws. So what are the strict action can be taken against them? A general observation.
What is the observation based on? What is the data that you have that the law has been misused?
For example, a woman who abuses a husband and she pretends that I am the one who is being abused, and if she is greedy for her husband's property or her paternal ancestral property is from her husband's side, and she fakes that as if they have been violent onto, and she sends a false video to the police also. So what does the law do?
See, under the Domestic Violence Act, what the woman gets is protection orders, okay? Residence order, there is no arrest of the husband or the respondent. So here, if the husband has been a victim of violence from the wife, he can make that as a part of his case when he's presenting it to show that there is no domestic violence committed upon the aggrieved person. And because there is no domestic violence committed upon her, she is not entitled to any of the reliefs. And the courts will take cognizance of that aspect. So if domestic violence is not brought out as a part of the application, then the woman would be denied relief. So when you say misuse, misuse of protection order, misuse of residence order, I think these are not aspects that are visible. Generally, people talk about property rights that become, the woman has tried to get over or take over property rights. So property rights, again, if we see Section 17, it talks about right to reside. It does not talk about ownership or taking away property. So these are things that are very important to understand because the reliefs are civil in nature. The ambit of misuse is very limited under the Domestic Violence Act.
For launching case for domestic violence or physical abuse of women by men, then it is necessary to lodge police complaint first.
No, it is not necessary to register a police complaint. You can include as a part of your application that for several reasons you have not been able to go to the police and register a complaint. However, you have come now and you want these specific reliefs. Generally, the police prefer to register a complaint or women prefer to register a complaint to create an evidence of the act that this is the injury or this is the violence that I faced, and to create a record of it they go to the police to complain. However, if there is no complaint registered, you can still go to the protection officer, get a dir form filled, and with the help of the protection officer present the case in court. The law allows that.
Can you elaborate if the brother is mentally ill and sister wants protection order?
See, mentally ill would again be something that you will have to ascertain the illness, to what extent it is. And this would require medical reports that are there, and what is he doing that is causing domestic violence based on his mental illness. So if he's being abusive based on his mental illness, and his mental illness is not certified or is not part of hospital records, then whether he's mentally ill is something that would have to be identified. Like in one particular case in court, it was a property dispute between the brother and the sister. And the brother had approached the court to declare the sister as mentally unfit, and to be transferred to a mental asylum. Now, when this case was brought before the magistrate, the learned magistrate asked the sister many questions, and based on the answers to the question, he came to form his opinion that this lady is mentally fit, and it is purported that she's mentally unfit so that she can be thrown out of the house. So there are various such instances where the court would ascertain mental illness, and based on that they would pass orders that are appropriate to protect the rights of both the parties.
There is only one physical fight between married couple with provocation from side of wife. Can it be considered as a domestic violence?
Yes, if it is even one instance, it can be considered domestic violence. Now, very often we see that physical violence is immediately reported, or physical violence is the only violence that is reported. There will be or may be instances of emotional abuse, there may be instances of verbal abuse which get neglected. So these are aspects which become very important to be brought, whether you are an aggrieved person or you're filing the case on behalf of the aggrieved person. And if you are the respondent, then you would have to stress on the fact that it happened because of provocation, or these were the circumstances that led to this violence that has been reported, and it does not fall within the ambit of domestic violence. So it will depend on which side you are and how you want to present your case in court. But even one instance of any of the abuses mentioned under law would fall within the ambit of domestic violence.
Can you please throw light on protection officer? Who and where are they?
Protection officers are officers appointed under the law. So if you see Section 9 of the Domestic Violence Act, you also see the rules that are there under the Domestic Violence Act. You will find that these are officers who are appointed. So it is a government appointed position. They are associated with the Women and Child Welfare Department, and the Women and Child Welfare Department is the supervising authority, okay, for the protection officers. So for every district, you will have a district protection officer, and then that district protection officer will have subordinate officers who are appointed for specific jurisdiction. Like for Vikhroli police station in Mumbai, you will have a protection officer. So there is one protection officer who has the jurisdiction of Vikhroli police station, Powai police station. Then there is Kanjurmarg police station. So there are different police stations. So in Mumbai, the jurisdiction is decided based on the police station. If you go to other parts, again at the taluka level, at the district level, you will find out that there are these officers who are appointed. Earlier, protection officers were given additional charge. So, government officers who were part of the Women and Child Welfare Department were given the charge of protection officers. Now we have independent protection officers. So a protection officer is given an office, a protection officer sits in government premises, and a protection officer is given an assistant to carry out the work. Now this protection officer has to meet the aggrieved person, fill the DIR, fill the form 1, form 2, form 3, and other forms that are required in the case of a domestic violence victim, present that in court along with the victim, take the aggrieved person, go to court. After the court takes cognizance of that case or takes the case on record, the protection officer under section 13 of the law will also have the notice of summons being done. So protection officers serve notices to the respondent in such a case. In cases of emergency, a protection officer can be reached for, any sort of medical and other assistance that is required because of domestic violence that is caused upon the aggrieved person. A protection officer is a assistant, or you can say is an officer who is at the disposal of the magistrate. So if the magistrate feels that a home visit report has to be produced, that there is a dispute between, say, a mother-in-law and the daughter-in-law, and the magistrate wants to know the factual situation of that house, the magistrate can direct the protection officer to go and conduct a home visit report. So the protection officer will go to the house and interview both the aggrieved person and the respondent and file a report in court. So a protection officer is an officer who acts on the discretion and directions of the magistrate. And whenever the magistrate feels that there is a problem, which needs a physical visit or a person to go and ascertain it, that is done through the protection officer. Very often in execution of orders, so if the electricity is cut or the person has to be taken back to the shared household, she was thrown out of the house and now there is an order to reinstate her in the house. So in such a case, the help of the or assistance supervision of the protection officer is mandatory. So very often in child custody cases, if the child was taken away from the mother and now the child has to be given back, or the custody has to be given back to the mother, it will be done in the presence of the protection officer as per the directions of the court. If there is a breach of protection order, if there is violence, there is an order and there is a breach of protection order, then again the protection order can be, a breach can be reported to the protection officer. The protection officer will record the breach and then take appropriate steps to bring it to the magistrate or bring it to the cognizance of the magistrate. So these are ways in which the protection officer acts under the provisions of this law.
How a respondent save himself from giving interim maintenance to working wife who have bombarded with all the false allegations?
See, when we talk about a working wife, now we have this judgment, Rajesh versus Neha. It is a 4th November 2020 judgment of the Honorable Supreme Court that calls for affidavit of assets and liabilities. So the applicant and the respondent are both directed to file their affidavit of assets and liabilities. So if a woman is working and she has income that is sufficient for her to provide for her needs, then the court will not order maintenance for the woman. But if the woman has children, then the court in that case may direct the respondent husband to provide maintenance for the children. If the woman is working, depending on her income and depending on the income of the respondent, the maintenance may be given to her or the maintenance may be denied. So just because she's working, it is not necessary that the maintenance may be denied. And she might have other sources of income, which if you are aware, you can mention it in your affidavit of assets and liabilities, and the court will surely take cognizance of that aspect. There are a lot of judgments that talk about maintenance to a working woman. So you can look that up and that will help your case.
If wife file false DV complaint against husband and mother-in-law without any complaint or legal notice through protection officer, so what will be the remedies to husband and his mother?
See, under the Domestic Violence Act, there is no need of a notice. The case can be filed directly in court. So if the case has been filed in court now, because we have this computerized system, so once the mobile number is fed in the computer, sometimes you get a message that a case has been registered in so and so court. So you can look up the net and see what is the case about. In any way, the notice or the summons of that case will be served upon you and you will receive a copy of that notice or the summon. So whenever anyone comes to you and gives you this notice, you have to ensure that you are also taking from them the copy of the complaint that is filed. So in some cases, they only give a one-page notice, come to court on so and so date. In some cases, they also give you the full complaint that has been filed in court. So it is very important for you to ask for that full complaint copy and receive it. When you receive a complaint, when you receive the notice of a complaint under the Domestic Violence Act, it is important for you to sign on the notice that you have received it with the date and the time. Okay. And also, I suggest that you write the number of pages that you have received. So, received pages 1, 2, so and so 1. Because tomorrow, if you go to court and you find out that certain pages have gone missing or certain pages were not given to you, this notice will serve as a proof that you have received only limited pages and the other pages were not given to you. Now, once you are served the notice, you have to appear in court. If you don't appear in court, and if the report of service of notice is given saying that we already served the notice, the court may pass ex parte orders. Many courts today are more liberal in passing ex parte orders once the report of service of notice has been filed in court. So go to court, request the court for some time to appoint a lawyer and read the complaint that is given to you or the application under the Domestic Violence Act, and start preparing your sentence to sentence wise reply. So based on every allegation that is made, you should be filing your reply to the complete application under the Domestic Violence Act. Once you have presented your case, the main defense for you is to show that there was no domestic violence and hence she is not eligible for any sort of orders under the Domestic Violence Act.
Ma'am, the next query is what all documents are required to support the case of domestic violence? Will the case be maintainable without sufficient documents? Also, ma'am, it is necessary to submit any supporting documents for physical abuse done by a respondent in past if there is no current evidence on body.
In cases of physical abuse, if you have gone to the doctor and you have availed medical services, you may have a prescription or you might have a test report that was done. So that can be presented as a part of your evidence for physical violence. If there is an impact of domestic violence that was done, that again can be presented in court. Okay. So, like in one particular case, a lady was hit on her ear, and she at that point in time did not report it as a assault by her husband, but she said it was a ball that was hit on her ear. Now she underwent medical treatment at that point in time. She had a few X-rays done. So all of that she filed in court in support of her claim of physical abuse. And she mentioned that because she did not want to complain against her husband, she did not inform the doctor that this violence was caused by the husband. In terms of other documentation, if it is a WhatsApp abuse, message that has been sent to you on WhatsApp, cybercrime, there is something that is to do with your computer wherein your husband has been abusive to you emotionally, verbally, or now even digitally. So a screenshot of all of that can be produced. Medical reports can be produced, and other documentation would include if you're the aggrieved person and you're asking for maintenance, then you need to show what are your expenses. If you are the aggrieved person and you claim to be abused or face domestic violence, then you have to make out a case of domestic violence. If you were physically abused, what did you do after that abuse? You have to specifically mention that. If you talk about verbal and emotional abuse, what was the impact of that abuse? You need to mention those aspects. In cases of sexual violence, if you had an abortion and that abortion happened for whatever reason, because you were beaten or you were thrown out or you were kicked, so these are some things that can form a basis of your complaint. Prima facie, the law is not very strict about evidence in matrimonial cases. Okay, it is the person who has to be able to show the court that yes, I was a victim of so and so violence, and prove it to the extent of the provisions of the Evidence Act. So that becomes important. Documentary evidence help, and they surely benefit your case. However, if they are not there, then based on the evidence of your relatives, children, friends, you can go ahead and prove your case in court.
Is it possible to file domestic violence case after 20 years of marriage?
Under the law, yes, because we saw the definition of domestic relationship. If you are or you were in a relationship, then that would amount to domestic relationship. So yes, it is possible to file. a case under the Domestic Violence Act even at a later stage.
If wife do not wish to go for mediation and husband wish to go for mediation to save his family and in paramount consideration of small child, on whose request court will hear or court has power to ask couple to go for mediation?
The court has the power to send the couple for mediation on the request of either of the parties. Okay. So if the husband feels that going for mediation is going to resolve that dispute between them, he can ask for the court's directions for mediation. However, under the Domestic Violence Act, we have this important provision of counseling. So if you feel that counseling is going to help your marriage, then you can ask for a specific direction under section 14 of the law for the case to be referred to a professional marriage counselor, and the court will do that. And then based on the sessions with the counselor and the report of the counselor, the next step can be taken. So if you want to save your marriage, I will suggest availing section 14 counseling instead of going for mediation.
Do the protection officer can be civilian or they have to be from police only, or any social worker can be a protection officer?
See, for protection officer, there is a appointment that is done. So at the moment, people who have applied for the post of the protection officer are taken. So now they are contractual. Protection officers are on contract, and protection officers are not police, or they are not part of the police force. But whenever these vacancies are announced, whoever is interested can apply for the post of a protection officer. There is an exam, I think, that has to be given, and then the subsequent appointment is done. However, we are in a view, or we are seeing around us, that protection officers today are contractual in terms of employment. They are not permanently employed as protection officers.
If husband and wife are living away from each other in separate homes, then domestic violence case can be made out as they are away from each other more than 10 years.
See, after, the case can be filed based on the time that they lived together in that shared household. But after 10 years, the aggrieved person or the wife will have to make out a case of domestic violence, and she will have to show how the domestic violence is continuing. So, in the 10 years, whether the abuse has continued, whether there has been violence, whether there has been whether he has been verbally or emotionally abusing her or economically abusing her. So she will have to show the continuation of violence in her particular case. And if she says that we live together for, at this point in time, and since 10 years we are living separately, and she does not mention violence that has happened in the 10 years, then her case may not succeed in court. So it is important for her to show the continuation of domestic violence if she wants to file a case in court.
Which department employs protection officers?
The WCD department, the Women and Child Welfare Department, the District Women and Child Welfare Department. Their head office for Maharashtra is in Pune. It is, you can look up and you will find details about them.
If wife is not allowing respondent to meet his child for 2 years, can a husband ask for compensation? If yes, under which section and act?
See, first of all, the husband would have to ask for access to the child. So in a domestic violence case, even the husband can ask for access to, meet the child. And depending on the denial of his right to meet the child, he would have to go under civil remedies for compensation. Under the Domestic Violence Act, he will not be able to ask for compensation. So if the husband is inclined to meet the child, he can file a custody petition in court, or he can ask for access of the child. About compensation, there is no provision under the Domestic Violence Act wherein a husband can ask for compensation for denial to meet the child.
Mother-in-law is not allowing to enter in the kitchen and blaming that she can't cook. Is it a mental harassment? Can it be a DV case?
So this would amount to emotional abuse. Okay. Emotional abuse can be made out in this particular case, wherein the person is not allowed to enter the kitchen, and there would be taunts, matlab tana mara hoga, that she cannot cook. So yes, it would be a case under the Domestic Violence Act, and the person can ask for protection residence orders, and she can make the mother-in-law as a respondent in the case.
Okay,
So
ma'am.
during COVID, there were a lot of cases of senior citizens that came to be filed under the Domestic Violence Act. And in this particular case, we saw that because the children and the mother were confined in the house, and because the property rates are increasing so much in Mumbai, there were cases where children threatened their mothers, saying that we'll do this and we'll do that if you don't transfer the house in our name. Now, in such cases, based on the threats that were there, and based on the taunts that were there, domestic violence cases came to be filed in court. So, even today, if we look at the statistics for the cases that are filed, in non matrimonial cases, that is, a mother filing a case against her children, and sister filing a case against the brother, a lot of these cases are also visible under the domain of the domestic violence cases. So it is not only matrimonial, but it is also the other way around. And in this particular case that you mentioned, it is also possible that the mother-in-law may file a case under against the daughter-in-law, and there bring out cases of abuse or violence. So there can be a case of cross cases of domestic violence, wherein mother-in-law may file against the daughter-in-law and daughter-in-law may file against the mother-in-law. That is also possible, and that is also seen.
Any concluding remarks from your end?
See, most of the cases that most of the questions that were asked with regard to matrimonial relationship in terms of domestic violence. So the only concluding remark that I would want to make here is that Domestic Violence Act can be used widely in terms of non-matrimonial relationship, because there is no other law that protects or talks about domestic violence in non-matrimonial relationship. So even the Senior Citizen Act that we have, it talks about maintenance and welfare of senior citizens. It does not embody protection to a larger extent. So in such cases, yes, the Domestic Violence Act can be taken as a benefit. And in terms of awareness of the law, there has been a lot of awareness about the Domestic Violence Act today, and there are cases which are filed on all fronts with regard to domestic violence. But as lawyers and law students, we need to ensure that if we are for the aggrieved person, we make out a case of domestic violence by mentioning instances, incidents, the impact of the violence that is caused as a part of our complaint. And if we are lawyers for the respondent husband, one of the main defenses that we can take is there has been no domestic violence, and hence no relief can be granted, or the aggrieved person is not entitled to any relief. And I think as a takeaway from this session, since there were a lot of questions about the protection officer, what you can do is go to your local police station, ask for who is the protection officer for that particular jurisdiction, get in touch with the protection officer, meet the protection officer, and understand specifically with regard to the duties and the appointment, etc., of the protection officer.